All right, let's talk about HOAs. If you live in one, you know you're supposed to have a right to see the financial records, right? But what even is a record these days? In our digital world, does that mean you can see everything? Well, we're going to dive into one homeowner's incredible fight to figure out exactly where that legal line is drawn.
So imagine this. What if you went to your HOA and said, hey, forget the monthly statements. I want the keys to the whole digital kingdom. Sounds bold, right? Well, one homeowner did exactly that, and it sparked a huge legal battle that actually helps define the limits of HOA transparency for all of us.
Okay, so let's get right into it. The case we're looking at is John Sellers versus the Rancho Madera HOA down in Arizona. And look, this was not your typical fight over what color you can paint your front door or, overgrown bushes. No. This was all about one thing: access to information. And things got serious in December 2016. I mean, legally serious. This document you're seeing, that's the actual court filing. John Sellers officially filed a petition, which is basically just a formal legal complaint, and his claim was simple. My HOA is illegally hiding records from me. Now, this is really the core of the whole thing. Sellers wasn't asking for the usual stuff, like meeting minutes or the landscaping contract. Nope. He wanted two very specific and kind of wild things: the signature cards for the HOA's bank account and a read-only password so he could log in and see the account for himself. And this is where the real battle lines were drawn. See, to really get why Sellers' demand was so explosive, you have to look at what the HOA said they had already given him.
Yeah, this lays it out perfectly. On one side, you've got Sellers' two really specific and, let's be honest, pretty unusual requests. But then you look at what the HOA had already coughed up. They weren't exactly hiding everything. They'd provided a literal mountain of paperwork: all the bank statements, management contracts, board resolutions, even insurance certificates. So the HOA is saying, hey, we're being totally transparent. But Sellers is saying, yeah, but you're hiding the most important stuff.
So what happens when you have a standoff like this? Well, you've got to turn to the rule book, the law. And in this case, the entire thing hinged on how you interpret one single piece of Arizona law that says what records an HOA has to show you. And this is it. This is the legal battlefield right here. A.R.S. Section 33-1258. I know it looks like a bunch of legal jargon, but this one little section of the law is what the entire case was fought over. Every argument from both sides came down to the precise wording you see here. Okay, so let's zoom in on the most important part. The law says all financial and other records of the association have to be made available. Now that sounds pretty straightforward, right? All records seems to mean, well, all records. But the whole case boiled down to one simple but super tricky question. Are bank signature cards and online passwords actually records of the association, or are they something else entirely? And that one question, that's what sent everyone to court. It turned into this epic showdown, not about money or what was spent, but about the true meaning of a single word: record. So John Sellers' argument was actually pretty clever. He basically said, look, thanks to federal banking rules, the ones put in place to fight terrorism, we know for a fact that these signature cards and passwords have to exist. The bank requires them. So his logic was, if they exist and they have to do with the HOA's money, then they must be records of the association and I should get to see them. But the HOA's lawyers shot right back with a very different take. They said, hold on a second, those things don't fit the legal definition. Their point was that the signature cards are actually records of the bank because the bank is the one that holds onto them. And a username and password, that's not a document, that's just information. It's not a piece of paper the HOA has in a filing cabinet to hand over. So you've heard both sides. It's a classic legal showdown. And it all came down to one person, the administrative law judge. How on earth were they going to slice this incredibly fine legal hair? And then on March 30th, 2017, the final order came down. This is it. The decision was made, it was official, and the ruling was in. The court sided with the HOA. So the big question is, why? Why did the HOA win? Well, the judge's reasoning came down to three main things. First off, custody is everything. The court agreed with the HOA. Since the bank is the one holding and controlling the signature cards, they're the bank's records, not the HOA's. Second, information is not a record. A username and a password, the judge said, is just a piece of information, not a document or record like the law describes. And finally, you got to look at the whole point of the law. The judge figured the law exists so homeowners can make sure the board isn't doing anything shady with the money. And you know what? The bank statements and contracts they'd already provided were enough to do that.
So there you have it. The verdict was crystal clear. John Sellers' petition was denied. The court officially found that the HOA did not break the law when they said no to handing over the signature cards and that banking password.
Okay, so that's a fascinating story from Arizona. But what does it mean for you, for the rest of us living in an HOA? Let's boil this whole thing down to some key takeaways that every homeowner should know. This chart really breaks it down nicely. Think of it this way. You have a really good shot at getting anything the HOA physically has and controls. We're talking bank statements, contracts, budgets, that kind of thing. But where it gets tricky, and where you might get a no, is when you ask for records that are actually held by somebody else, like a bank, or when you ask for something that's just raw information and not a real document, like a password. And it should go without saying, but you can never get another member's private personal info. And this whole thing leaves us with a really big question, doesn't it? This case was decided based on the idea that a password isn't a document. But our whole world is digital now. So are these old school definitions even useful anymore? I mean, should the laws change to admit that, hey, maybe a read-only password is the best and most direct way to check the financial records in the 21st century? What do you think? It's definitely something to chew on.